Francisco Ethics Commission. We'll begin by taking the roll. Commissioner Liu.
Here.
Commissioner Han.
Here.
Commissioner Rennie.
Here.
Commissioner Studley has an excused absence today. Our first order of business is consideration of the draft findings and legal justifications for the Commission's decision on August 16, 2012. We have posted and circulated a written document that summarizes what was done on the 16th. Thanks to Commissioner Liu and Mr. Embledge for playing a significant part in putting this document together. Before we begin, one issue I think should be made clear. There seems to have been some confusion about whether or not the Commission was going to provide some recommendation as to what the effect of the recommendation of official misconduct should be. Having reviewed the transcript, and certainly my personal understanding of what we decided on the 16th was that there was no need to provide any explanation or suggestion of what the effect of a recommendation of official misconduct would be, because the charter clearly states that if there is a finding of official misconduct, then the person found to have committed official misconduct shall be removed from office. So it seemed to me that there is no discretion for the Commission to determine or to provide a recommendation to the board as to what should happen should the board find that the sheriff committed official misconduct. So I just want that to be clear in terms of why our order doesn't address what the effect of the finding should be, is because the charter really provides no option. Commissioner Han.
While that may be the case, I do understand that the charter spells out what the punishment should be based on our recommendation or finding Sheriff Mirkarimi guilty on those two counts. I do feel that there has been a tremendous amount of confusion about this in the public and even in the media to some degree. And even if our recommendation really has no bearing in the case of what the punishment should be, I feel that the Commission should at least go on the record as to what we feel the punishment should be. And the board can certainly ignore that particular recommendation or use it to bolster whatever arguments take place when the board has its hearing. But I, for one, feel that the Commission should have and still should consider a vote on what the punishment should be. And if it's not inappropriate, I myself would like to make a motion to that effect. I don't know how the other commissioners feel about this. Just for the record, I mean, I realize that the legality, it doesn't, it's not necessary in view of what the charter recommends, but I do think that we should be on the record.
I guess my concern with that is we would be recommending action to the board that they cannot take. I mean, their options, I think, are to either find that the sheriff committed official misconduct or find that he has not committed official misconduct. If they find the former, then the charter is clear that he needs to be removed from office. If they find the latter, then it's clear that he is not to be removed from office and is to be reinstated. So I think a recommendation to the board of something they can't do would not be productive. I don't know if any other commissioners...
Well, let me just say that, as you probably are aware, the Commission on the Status of Women passed a recommendation, or at least a stance, recently, and they have no bearing on the official proceedings whatsoever, but they want to go on the record as to what they feel should be done.
Let me say, Chairman, I tend to disagree with your reading of what power the Ethics Commission would have As I think I said very early on, and although I'm sort of alone in my broad reading of the definition of official misconduct, it appears to give the mayor discretionary power, not the section that deals with felonies makes it mandatory. The section that just talks about official misconduct says the mayor may suspend or punish. So that, as I said earlier, I thought our analysis is a two-step analysis, and that is, first, do we make a finding of official misconduct? And secondly, was the suspension by the mayor appropriate? And the reason why I feel strongly about that is it in a way addresses what your concern was when you say, with my broad reading of the statute, it gives the mayor unlimited power. I say it doesn't give him unlimited power if at the hearing it became clear to us that the mayor was acting solely out of a political motive or some bad motive other than that, so that the conduct, the official misconduct that he found, we might feel was not sufficient or did not justify suspension. Now, I agree with the fact that in this case, I would say I would not recommend that the mayor abused his discretion based on the facts in this case, of everything I've heard. But I do not subscribe to the view that if we make a finding of official misconduct, that's the end of our analysis in every case.
Okay, well, I certainly don't think that we should be deciding here what would happen if we found that the mayor had engaged in some sort of prosecutorial type misconduct. Right. I mean, I don't think there's evidence of that in the record, and I don't think that we should be providing advisory opinions as to what should happen in that event. And neither do I think we should be providing advisory opinions as to what should happen if the mayor had not requested that the sheriff be removed from office. But unless someone points me to something that says the board or we can recommend or do something other than remove him from office if there's a finding of official misconduct, then I don't see the benefit of providing any other recommendation to the board. Commissioner Liu?
Thank you. I do understand Commissioner Hayon's concern for taking a position on the consequences and what effect the misconduct charges should have. However, I think that I am more inclined to agree with Chair Herr on this particular issue and the reason is because we were so careful in analyzing what the charter says and what the standards were, and we parsed the language. We were trying to be true to what each of us felt the charter allowed us to do and not do. So I would not feel comfortable now straying from that principle and doing something that I really don't see that the charter allows us to do. So for that reason, I wouldn't want to take a recommendation on it simply because that's not what I think we're authorized to do under the charter. And if we've been true to what we each believe the charter allows or doesn't allow, and I understand Commissioner Rennie's point of view as well, but for myself, I think because I've been sticking to what I think the charter allows and what it doesn't allow, so I wouldn't stray from it at this point, at this stage. So from my point of view, I think our job was just to give a recommendation about whether to sustain the charges, and that's it. That's all we were asked to do and tasked to do. So for that reason, I am also not inclined to take a vote that I probably don't see that we are authorized to do and make some kind of recommendation that isn't found in the charter or isn't grounded in the charter.
Mr. Embledge, do you have a view on this?
I stated my view, I think, at the last meeting. I believe that the mayor has discretion about whether to bring charges, but the charter spells out what decision is required of this body, and that is to decide whether or not to sustain those charges. That doesn't mean that there be anything unlawful about you making other recommendations, but what the charter asks of the Ethics Commission is, does it find that the charges are sustained? And then what it asks of the Board of Supervisors is the same question, and if 3/4 of the Board of Supervisors vote to sustain the charges, then there is no discretion on the penalty. The penalty is removal from office. So I think the charter anticipates a decision here on whether or not to sustain the mayor's charges, a decision by the board as to whether or not to accept your recommendation, nothing more, nothing less.
Commissioner Hand, was there anything further that on the issue of making a motion for us to vote on what the penalty should be? I think I'm not in favor of that because for the reasons we discussed. If you want to put in something, I guess if there was some sort of concurring type opinion you wanted to put in statements about what your view of the punishment should be, that might be something we could add, not as part of the majority opinion, but as something separate. I suppose that's something that could be done, but I guess I would ask what your viewpoint is on whether that's something you'd like to do.
Well, I mean, based on the discussion and what Mr. Embledge has indicated and has been indicated before, our charge, I guess, is quite specific, and that is to decide on the merits of the thing of what we voted. The counts on which we agreed Sheriff Mirkarimi was guilty. I don't want to go beyond what the charter asks us to do. I think on a personal level, I want to be clear about what I feel, and I don't know if this is the appropriate place to do that. If it is, then I would, certainly add something to the report. It's not a dissension, but just to be on record of what I feel should happen when the board considers this, but it's not an official recommendation.
Any other views on the issue of a proposal to the board on penalty?
I mean, I think it would be entirely appropriate for Commissioner Hayon to add something into the report on her view. I think that would be appropriate to let the board know.
I am fine with that. Now here the issue though is timing. I certainly don't want to have to meet again to ratify this document again. So I think if you want to put something into the record, if you want to right now put in language into the record on your concurring view, then I think that would be fine. But I'm not inclined to have a procedure where you go back, draft it, and then we come back and have to ratify something.
And I'm not. Under no circumstances am I suggesting that we do that. But if I may, then I certainly would like to go on record that while we are not charged as a commission in making a recommendation on the penalty, I want to be clear that my own view is that based on our findings that the appropriate punishment should be removal from office. And that is my personal view, and I would just like to make sure that that is on the record.
Public comment on this motion?
There's no motion. Okay, so the proposal is to add a concurring view from Commissioner Hayon stating that she supports a finding that official misconduct should result in the sheriff being removed from office. Is that fair? Okay, so we will consider that. Oh.
So my question is, will that simply be on the record in the minutes of today's proceeding, but not in the official document, so that we don't have to go back and review it?
Well, I guess it's up to you. What I was suggesting was that if you don't want it in this document, then that is fine, and we wouldn't have to go back and review. I suppose there is an option for you for essentially Mr. Embledge to put in this document right now, that language, and us to vote on it as amended.
Okay.
But if you
That would be fine with me. What I don't want is to hold up the proceedings. I mean, I think that all of this has gone on probably far too long as it is, so I do not want to do anything that would hold up these proceedings any further.
Okay, so the draft, as currently amended, and I'm sure there will be other amendments, contains a one-sentence concurrence from Commissioner Hayon. Mr. Embledge, do you have that language in mind?
The language I have is Commissioner Hayon supports a finding that the official misconduct in this case merits the sheriff's removal from office. Is that accurate?
That is accurate.
Okay. There were some additional edits that were proposed by the mayor, and I think that they are accurate. So I would propose that on page 2, lines 1 and 2 should now read, "This matter presents the first time that the Ethics Commission has provided a recommendation to the Board of Supervisors regarding charges of official misconduct under Charter Section 15.105.
Did you get that? No.
Okay, let me try it again.
Please.
This matter presents for the first time that the, and strike, mayor has presented the Ethics Commission has provided a recommendation to the Board of Supervisors regarding charges of official misconduct. So you would strike the with, and you would strike in line 1, mayor has presented the. Is there any objection to that from the commissioners? The next edit that the city attorney proposed, which I think is correct, is on page 4, line 1. Line 1 begins, "Examine any witness except the mayor." The city attorney has pointed out that the sheriff also cross-examined Chief of Police William Lansdowne. So I think that it should now read, "Except the mayor and San Diego Chief of Police William Lansdowne." Any objection to that from the commissioners? Do the commissioners have any proposed edits to any of the remainder of the document? Commissioner Rennie.
I have 3 suggestions for additional language, but again, if in any way that would delay these proceedings, I pass on them. But I believe that they're consistent with what the record was and what the conversations were back on August 16th. And that I would, in paragraph number 3 of findings of fact, on page 5, after what's typed in there, on or about December 31, 2011, during the time he was incumbent supervisor and Sheriff-elect Ross Mirkarimi committed acts of verbal and physical abuse against his wife, Eliana Lopez. Among other things, Mr. Mirkarimi grabbed Ms. Lopez with such force that he bruised her upper arm. I would propose to add in the following sentence. In that regard, the Commission did not find creditable the version of the incident as described by Ms. Lopez and the Sheriff at the hearing before the Commission. Rather, the Commission found that the evidence contained in Ms. Lopez's video was more creditable. I think that is helpful not only to the board, but based upon the public comments that we've received, which accepted the version and the testimony that was heard at the Commission, by the Commission from the Sheriff and Ms. Lopez. There are many who have argued that, well, it was such a minor incident that it shouldn't be misconduct. And yet, I think, as Commissioner Studley remarked on the 16th, that was a very powerful video and was more credible and more believable than the very sanitized version that we received at the hearing.
Mr. Emlich.
I got most of that, I think. But I have, in that regard, the Commission did not find credible the version of the incident as described by the Sheriff and Ms. Lopez at the hearing, period. Rather, the Commission, and that's where I ended,
finds that the evidence contained in Ms. Lopez's video was more credible.
Thank you.
I think my concern with a statement like that is its breadth. I mean, we're sort of in one sentence making some broad statements about a lot of testimony. I'm not sure that there was agreement that everything that the Sheriff and Ms. Lopez said about the incident were not credible. And moreover, that's not really a finding of fact. I mean, what I think we have here are facts, things that we say happened, that we agreed happened, rather than weighing the credibility of one witness over the other. I think the vagueness of this is problematic to me. I would not have voted for that. Welcome the views of my fellow commissioners.
I agree with Commissioner Rennie. I actually think we had quite a bit of discussion about the video, and I think it is important to understanding our recommendation, or at least the recommendation of the majority. I do think it's important to understand why we found what we found and why we found it to be official misconduct, and that was a big part of the discussion. So if it's perhaps not appropriate in the findings of fact portion, perhaps we can insert that sentence in the discussion of the majority view.
I think it would be more appropriate there.
I have no objection to going there. The second suggestion that I had goes to item number 7 on the findings of fact, which is that March 12, 2012, Sheriff Mirkarimi pled guilty to the crime of false imprisonment of his spouse, period. And again, my comments, it may be that it should go in the, rather than the findings of fact, in the discussion portion. But I would add, and was sentenced to 3 years probation, 12 months of domestic violence I forget the exact language, but we know the exact language, we can get the exact language, and a fine. It is this conviction and sentence which brings the misconduct within the time period when he was officially the sheriff. And my concern here is that one of the issues raised by the sheriff, and I think justifiably, because it is a legal issue that at some stage may have to be resolved, is the conduct occurred before he became a sheriff, and without the conviction occurring during his tenure, there might be some real difficulty in saying that that conduct could constitute official misconduct. But having pled guilty to false imprisonment, that I think satisfies the bringing whatever defense you have that the conduct occurred outside the time that he held his office as sheriff. And I guess I just want to, again, make it clear that we recognize that's an issue. And that is, at least in my mind, how that issue gets resolved.
I think there's 2 points there. I think that the fact of the imprisonment, the sentence, the consequences of the basically, yeah, this adding in the sentence is fine to me. I think that is consistent with what we found. I am getting a little concerned if you are trying to add post hoc justifications for the decision that was made on the 16th. I don't know that we discussed on the 16th that the timing element is satisfied by the plea. Maybe if we did, then I think you can put it in, it should be put into the majority if that's what the majority wants. In the fact section, I don't think that part should be included. Views from the other commissioners on this?
I was just looking through the findings of fact that have been proposed, and so I guess that particular portion is not in the findings of fact, but I would be fine with adding it to the majority discussion.
Commissioner Liu, you're saying that the sentence imposed was not included in the findings of fact?
Right. The specific sentence imposed, I don't see it in the parties' joint findings of fact. I don't see that. Actually, you know what? It's in the amended charge, but I don't see it in
I think that was likely stipulated to, so
right.
we have to make a finding on it.
Okay, that's probably right. So where does that bring us?
Do the parties disagree with that? I think it was, the sentence was stipulated to. Mr. Wagner, do you have a view on that?
I would object to adding any language that attempts to change what the commission decided on August the 16th. That's not ultimately relevant to what the commission is tasked to do.
I can appreciate that view, but my question is, did you stipulate that what the sentence was? Okay. Thank you.
But, you know, that's not reflected. We stipulated to several of these facts, but the way it reads here is that the commission unanimously finds that the mayor proved the facts. Well, you know, if we stipulated to the facts already, then the mayor didn't very well need to prove them.
Okay. I have no objection to putting in the sentence in finding of fact 7.
Excuse me, but I need that sentence then. What I have is, and was sentenced to 3 years probation, domestic violence counseling, and a fine, period. It is this conviction and sentence that...
Okay, that part I don't agree should be put in the findings of fact.
The sentence I just started?
Yes.
Okay.
And I think whatever the sentence is should be accurate as reflected in the stipulated portion of the amended charges.
I agree.
If it would assist the commission, I can tell you where that language is located. I can tell you where the language is located. It's in paragraph 31 of the amended charges of official misconduct. And it's the second sentence. The court imposed sentence consistent with the March 12, 2012 plea agreement and ordered Sheriff Mirkarimi to be placed on 3 years probation under the supervision of the San Francisco Adult Probation Department under the terms and conditions that he was to, and then it just sets that forth. You may want to shorten it, but that's the stipulated language from the amended charges.
What was the last clause?
I actually did not finish. Under the terms and conditions that he was to serve 1 day in county jail with credit for time served, perform 100 hours of community service pursuant to Penal Code Section 1203.097, enter, participate, and successfully complete 52 weeks of domestic violence counseling pursuant to Penal Code Section 1203.097, pay a $400 domestic violence fine pursuant to the same code section, and enter and complete parenting classes if deemed appropriate by the Adult Probation Department.
Would it be sufficient to say that the court imposed a sentence consistent with the March 12, 2012 plea agreement as reflected in paragraph 31 of the amended charges?
Fine with me.
Yeah, that's fine with me, too.
Yeah, that's what I would propose. Now, to the extent that the majority wants to add language to the majority portion of this order, what did you have in mind, and is there actually agreement to include such language? I mean, and I do think the commissioner should consider the danger of adding justifications that were not addressed at the hearing. I do not have perfect memory.
I'll withdraw them.
Okay. Commissioner Rennie, you had a third amendment?
No, that's all I have. Thank you.
Well, Commissioner Rennie, you're withdrawing the proposal with respect to the conviction, but what about with respect to the credibility issue?
No, I was just the latter one that we were talking about because the chairman has raised the question that we may not have specifically discussed that matter on August 16th, and I don't want to confuse the record, so it speaks for itself.
Okay, with respect to Commissioner Rennie's first proposal on the credibility issue, I think that can go on page 6, at line 6, right after the quote, the end quote, and right before, in addition, this conduct relates.
Mr. Embledge, do you have that?
Yes.
Can you read that language again?
In that regard, the commission did not find credible the version of the incident as described by the sheriff and Ms. Lopez at the hearing. Rather, the commission finds that the evidence contained in Ms. Lopez's video was more credible.
Commissioners, I'm just going to make a general objection to including that. I don't believe that the commission did, in fact, make that determination as to credibility. If the commission did so, I would appreciate a cite to the transcript.
I think that the majority is right, that we did discuss that extensively. It wasn't a basis for a finding of fact, but there was a uniform, I think a uniform view in the majority's opinion that the video was more credible than the testimony. And, you know, I think they're entitled to provide the board with the view they stated on the 16th as to how they view the evidence. So Your objection is noted. If any other commissioner would like to respond, I open it up. Any other proposed changes to the draft order? Okay, at this point, one other thing that we should discuss in relation to this order is the presentation to the Board of Supervisors. I understand that the board wants someone from the commission to provide a short presentation as to the findings that the commission made and the procedure that the commission followed. I'm proposing to the commissioners that Mr. Embledge play that role. I think he's clearly a neutral in this. He's been here for all of it. He drafted large parts of this order and has, in large part, been following and closely tied to what's been going on here. Any other views from my fellow commissioners?
Heard on that?
Yes, Mr. Wagner.
I also have some suggested changes to the findings of fact and recommendations, so I can address that first.
Sure.
I in general object to the overall language of the draft findings. I think that the document is very one-sided. It doesn't mention, for example, that the commission unanimously rejected many, if not all, of the contested factual allegations made by the mayor, for example, as to misuse of guns, as to dissuasion. The commission unanimously objected those allegations. That's not reflected in this document. Also, as to page 4, where it says that the commission denied the sheriff's request for issuance of subpoenas as to collateral issues, and then describes those issues, the issue was whether or not the mayor committed perjury. That was the issue, and that's why we requested those subpoenas. That is not reflected in this document. And finally, and most importantly, well, two other points. On page 5 in the findings of fact, in paragraph 3, it refers to quote-unquote acts of verbal and physical abuse without saying what those were. I don't think that the commission actually made a determination, other than the arm grab, that there were any other acts of quote verbal and physical abuse. Similarly, the sentence right after that uses the phrase with such force. Obviously, if the arm was bruised, then that's implied. So I don't think the commission had a discussion about whether or not to use that phrase. And then finally, on page 6, the first sentence of the recommendation reads, the board should sustain the charges of official misconduct against Sheriff Ross Mirkarimi based on, et cetera, conduct on the incident on the 31st as reflected in counts 4 and 5. I take strong issue and object very strongly to the commission making this recommendation as stated here, because that's not what the commission decided. The commission did not decide to recommend that the board should sustain the charges, right? So, and Commissioner Rennie pointed out on August the 16th that the counts are the same as the charges. Well, the commission did not unanimously or otherwise sustain any of the mayor's counts in their totality. Rather, the commission decided that there was official misconduct going back to the incident on December 31st as reflected in counts 4 and 5. That's not the same thing as sustaining counts 4 and 5. The commission did not sustain or recommend to sustain counts 4 and 5, and the commission certainly did not recommend to sustain the charges, which implies all of the charges. So I think at a minimum, this document should be clarified to reflect what the commission actually did and did not do, but it did not sustain the charges, certainly not as written by the mayor. And I think this document should reflect that the commission did not sustain any of the 6 counts, and in fact only found that 2 of the counts, 4 and 5, there were elements of those counts, parts of those counts that the commission, a majority of the commission agreed with, but certainly not all of either of those counts.
Let me start with that particular point, and we'll address each of them in turn. On your last point, you're complaining then about the statement on page 6, line 1 through 4, is that right?
Yes.
Okay, so you're saying that we did not say that the board should sustain the charges of official misconduct against Sheriff Ross Mirkarimi based on the seriousness of the incident that occurred on December 31st, 2011, and the subsequent conviction as reflected in counts 4 and 5 of the amended charges of official misconduct. That's the part you're complaining about, right?
Yes, and specifically the first 5 words.
Okay, well, on page 1611 of the transcript, there is a motion that says, is there a motion to sustain the charges as to the conduct that occurred on December 31st, 2011, and the subsequent conviction as reflected in counts 4 and 5 of the amended charges of official misconduct? So I think it's pretty clear that the order reflects the motion that was made, seconded, and approved by the commission. Okay, your concern about the facts that are not included here, meaning the fact that we found that there wasn't sufficient evidence on the guns or other conduct. I'm certainly not suggesting that we didn't make those findings, and I stand by them, and I think we were absolutely right to find that the mayor did not sustain his burden on and many of the facts. But a finding of fact is a place to put in what we actually found, not what we didn't find. So that's why we didn't include those in there. With respect to with respect to your concern about how we crafted the language on the denial of the subpoenas, I suppose I'm open if you think that there should be word changes, but I think this accurately reflects what we decided. Do you have specific things about this you think are inaccurate?
Well, I think that, earlier you referred to the fact that the commission did not decide that the mayor committed prosecutorial misconduct. Well, that was, I don't know if you'd consider lying under oath prosecutorial misconduct, but it was certainly alleged, and we requested subpoenas, and the commission declined to even look into the issue. The commission declined to even consider whether that was relevant. I think the board in this document, the summary, that was a major aspect of this case. It was reported on for weeks and weeks in the press. 2 city officials were ready to testify under oath as to the mayor's perjury. I think that should be reflected. This language minimizes all of that.
Mr. Wagner, all due respect, we didn't ignore it. In fact, I think we talked about it at some length. We made a decision about it, and we decided that the evidence was not direct enough and or was too collateral to address. And it's in the record. The board can look at it. I frankly think this language accurately reflects what we decided. If you have specific words you think are inaccurate, you can point them out. But I certainly don't think this should come out. This is simply a reflection of what we decided. We're not making any judgment calls as to, in this paragraph, as to whether or not the mayor's testimony was otherwise credible.
May I add something?
Yes, Commissioner Liu.
In addition, I also think it's important to remember that Chair Herr, during that meeting, whichever date that was, that we discussed your request for additional evidence and testimony, that Chair Herr pointed out that perjury charges are not and were not before us. Our commission was not asked to pursue charges of perjury against the mayor. Your request to us was whether to allow evidence from 4 additional witnesses on these other issues, and your hope was to impeach the mayor with those additional issues. And so what we discussed and what was briefed was the fundamental rule of evidence that we have the discretion and courts have the discretion to not allow evidence and witness testimony for the purpose of pursuing issues that are collateral and not directly relevant to what's going on and what's at issue in the hearing. So I would like to just state for the record that we were never asked to pursue perjury charges, and we're not the body to do that. That's not our job, and that was never our job. Whether or not to decide to pursue perjury charges against the mayor is not within our purview at all. So I just would like to correct the record on that.
Any other commissioners want to weigh in on any of those?
I am somewhat sympathetic to your statement that there's nothing in here that reflects the fact that we rejected a number of the charges that were filed by the mayor. And is there some language that you specifically would like to have us insert and where you would like to have it so that the board is aware of the fact that, in a sense, we only accepted one charge of misconduct, and that was a misconduct relating to the incident of December 31st and the conviction. And everything else that the mayor chose to throw in, we rejected. I agree. And I don't have any problem if you want to put that in. I don't know if the other commission members were, but I think it's a fair statement.
What do the other commissioners think about that? My concern is that when you start saying facts that weren't proven, you kind of open the door to, well, how many should we include and exactly how should we say them? That said, I certainly crystal clear in my mind that we found that certain allegations were not proven, and if the commission feels that we should add them, I don't necessarily have a problem with that. As a practical matter, the crafting of language is may present some issues. So with that, I ask whether Commissioner Han or Commissioner Liu have anything to add.
Is what you're proposing, Mr. Wagner, something along the lines of that the commission did not find the evidence sustained charges of witness dissuasion and interference with a police investigation? Those are the two that stick out for me, perhaps, if you wanted to include a sentence along those lines.
I think the guns would also be the third major allegation that we found was not proven.
Thank you, commissioners, for considering this point. I think my concern is that, as Commissioner Rennie said at the last hearing, the counts are the charges. So when the commission is saying in this document the board should sustain the charges, that implies that the board should sustain the counts, when in fact the commission rejected 4 of those counts completely, and that's 1, 2, 3, and 6. So I think this document should reflect that fact, and simply by saying the board should reject counts 1, 2, 3, and 6 completely, and as to counts 4 and 5, I'll leave it to the commission. I mean, that language is already in here, and I do think it's clear that the commission, well, it's not entirely clear. I think the commission should be clear in this document to say that they rejected all of the counts as drafted by the mayor. That is a fact, and it does not reflect that here.
One of the problems I have with your statement that we rejected 1, 2, 3, and 6 is they were rejected because they concluded so many things, and I've got to say, from my point of view, one of the frustrations is there was never one simple charge saying X and Y. They added everything and all of them, and I think our problem when we went to 4 and 5 was because they were the ones that were closest to what we found to be official misconduct. That is part of the problem.
I completely agree, Commissioner Rennie, and my reading of the charter is that it does not empower the Ethics Commission to redraft the charges. If the mayor made an error in charging, I don't believe that the Ethics Commission has the power to cure such a defect after the fact by redrafting the counts.
I'm looking at count 4, and my understanding of what the majority did is that they found each element of count 4 was met. I mean, the problem that the commission had was the incorporation by reference of paragraphs 1 through 46. But I think the commission found that Sheriff Mirkarimi was a public officer at all times during the events, that he engaged in wrongful behavior by committing the crime of falsely imprisoning his wife, resulting in, his criminal conviction, that his behavior was wrongful and willful, and that the crime, conviction, and sentence is related. Well, maybe each and every duty of his office may be overstated, but I think the majority found that it related to his duties. So, is that consistent with your views of what the majority decided?
Yes, I think as to counts 4 and 5 for sure. As Commissioner Rennie said, we struggled a little bit with the other counts because they included so many other elements. I do not think it's accurate to say we rejected in their entirety, for instance, count number 1. We talked about that count in particular and decided, we'll just go with 4 and 5 because 1 did include a number of things that we weren't sure, some people may have agreed and some may not. And so that one, I feel strongly that we did not unanimously reject count number 1. So for those reasons, I would say I think it's just better to say what we did find and not what we didn't find.
Well, then, and thank you, Commissioners. In that regard, then I think this document should reflect the language that Commissioner Herr read from the transcript, which is more accurate. And that's, I believe, on page 1611 of the transcript. And that's sustain the charges as to the conduct that occurred on December 31st, et cetera, as reflected in counts 4 and 5. That makes it very specific that, well, that's just what the Commission decided. And this language here is more broad. The language in the document is not the same. It says sustain the charges of official misconduct, et cetera.
I mean, it's substantively the same. Sustain the what is the substantive difference in your mind? I mean, it's referring to the identical conduct. It's saying sustain the charges as reflected in counts 4 and 5. The only difference is that we added what was certainly implied in the motion, that it's charges of official misconduct, rather than charges as to the conduct. I mean, if the majority wants to change that to the exact language of the motion, I guess I have no problem. This just seemed clearer as to what you all really did, but I leave it to you.
Well, I don't believe that the board ever, or excuse me, the commission ever actually took a vote and said, we're going to sustain counts 4 and 5. It said, we're going to sustain that we find that there was official misconduct as reflected in counts 4 and 5, which is not the same thing.
Okay, well, what's in the order right now is the as reflected language. So you still have your argument that
I agree.
Right? I mean, so you don't, I don't think you want language that weakens your position in here, so, right? So
I agree. Thank you.
Okay.
So, and if I may now address the issue of Mr. Embledge representing the commission before the board, I think this is a thorny issue. As the commissioners are aware, we initially filed a motion to, or may be aware, we filed a motion in civil court to have the city attorney's office disqualified from the case. The Ethics Commission, of its own accord, determined that it should hire or retain outside counsel. It did so. And throughout this process, to my knowledge, Mr. Embledge has been representing both the commission and the board simultaneously. Now that the commission, by a vote of 4-1, has decided to move forward with the mayor's efforts to remove the sheriff, or at least find that he engaged in official misconduct, it occurs to me, or it seems to me, that the commission takes on a prosecutorial role in trying to convince members of the board of the mayor's position, at least as reflected in counts 4 and 5, so that you now have the same attorney who's now taking on a prosecutorial role advising the decision maker. And I think that raises a conflict of interest, and we would therefore object to Mr. Embledge representing the commission before the board.
How is he? I'm not sure. Mr. Embledge wouldn't be advising the board. He would be the spokesman for the commission to tell the board what the commission did. But it's up to, he's not going to be the one to tell the board what it should do, I gather.
He is providing legal advice to the board. He's acting as the board's lawyer as he is the commission's lawyer. I don't know if that contradicts your statement or not, but he's playing the same role for the board that he played for us.
Why is that?
Because that's what I was asked to do, to provide outside advice both to this commission and to the Board of Supervisors on the process.
If Mr. Embledge is only planning on discussing process questions before the board, then we would withdraw the objection. But my understanding is Mr. Embledge has set, or whoever is going to be representing the commission is, if I would presume, going to be advocating for the commission's position.
See, I guess that was not my understanding. My understanding is that we're going to have a different procedure than is typically occurs at the board, that it would be a shorter presentation that would provide for the board what we did, the timeline on which we did it, to the extent necessary, what evidence we considered, and then, to the extent necessary, summarize the findings that are already in this document. I'm hoping that's actually redundant, given that we have the document and they have the transcript, which is why it didn't seem like it would be a conflict. I mean, I hear your objection, and I'm certainly sensitive to not only sort of actual conflict, but potential conflict as well. So, Mr. Embledge, let me put you on the spot. Do you have a viewpoint in light of Mr. Wagner's comments?
I think Mr. Wagner raises a good point, mainly on a perception issue. What I believe the board is seeking, and what I felt I could do without putting myself in a conflict situation, is simply report to the board what this commission did and what findings it made, and essentially reiterating the written document. The board wants someone there to be able to make that presentation and answer questions. I don't think there's an ideal solution to who that right person should be. If it were the chair, it would be awkward because the chair is the one dissenter from the decision. If it were one member of the 4-person majority, that could be awkward because that person might be asked questions to speak for the entire majority and might not feel comfortable doing that. If it were me, there is some awkwardness between the legal advice I might be called upon to provide to the board and my role as making what I hope to be a very dry and neutral presentation of what the findings are here. But it puts me in somewhat of an awkward situation, so I don't disagree with Mr. Wagner, but it may be the best of the alternatives to have me do it given my neutral position, but I'm open to whatever the commission would like.
Mr. Wagner.
I think Mr. Embledge said it very well when in pointing out that it raises a perception issue. You know, the question is... Well,
so are you advocating then that rather than Mr. Embledge, who's going to give a neutral, as he put it, dry presentation, you would want someone from the majority to go there and make the presentation? Is that what you're suggesting?
No.
Well, who do you think should do it?
Well, we objected to anyone from the committee.
Well, so we're going to send someone, Mr. Wagner. So if you're going to object to Mr. Embledge, who would you, I mean, you're,
I don't think it's fair, respectfully, Commissioner, to put it back on us to determine who is the best person to advocate your position to the board
we're
for
giving,
the process.
okay, we're giving you an opportunity to weigh in on how we should present this to the board.
But
So
it's
if
not-
you are, if you're going to object to Mr. Embledge and you have no other suggestion, that's fine. But I'm giving you that opportunity, and if you decline it, that's fine.
Then I would respectfully suggest that the director, Mr. St. Croix, explain the procedures in the commission's position to the board. Ultimately, as Mr. Embledge said, there's a perception issue. And the Ethics Commission, I believe, should take every action that it possibly can to avoid the perception of impropriety, to avoid the perception of conflict, the appearance of conflict. So that's why I raised the issue. And I think that the director making the presentation would alleviate that concern, because the director is not counsel for the commission or the board.
I guess I'm a little confused as to why the board can't have other counsel.
I have no objection to the board retaining other counsel.
I'm just, I didn't realize that your engagement at the present time, that you're engaged by the board. Have you been advising the board during our proceedings?
Yes. And there's been one meeting about procedure with the board. One public meeting.
I apologize, Commissioners. I'm sorry, were you waiting? Did you have a question, or was this a general pause?
No, I'm just, I guess I am a little surprised, and I don't know why the board doesn't have independent counsel.
I can't answer that question. I'm doing this pro bono, and if you'd like to cut off my pro bono time.
Then we're very appreciative. We're very appreciative of all the help you've given us, and I'm just a little surprised that it wouldn't be obvious to the board that there is, to a certain extent, a conflict between you're advising us and they're the decision makers, and having to, because we aren't the decision makers, we just make a recommendation. But be that as it may, I guess I would suggest the solution is for the board to get counsel, find another pro bono.
I would just also add, respectfully, Commissioners, and with all due respect to Mr. Embledge, it's my understanding that Mr. Embledge was retained by the City Attorney's Office of the City and County of San Francisco. Mr. Embledge's firm has, as a client, the City and County of San Francisco. So that is a further reason why that we believe that the board should have independent, different counsel.
Okay, well, one thing I'm sure we can't decide is who the board's lawyer should be. Okay, so I don't want to hear anything about who the board's lawyer should be. I can't weigh in on that. I can't make any decision about that. None of us can here. What we're trying to figure out is who should make the presentation to the board. You're saying you don't want Mr. Embledge. You object because of perceived or maybe you're alleging actual conflict of interest. Is there anything else you want to say about that, about whether or not Mr. Embledge should give the presentation?
No, thank you.
Okay. Anything else, Mr. Wagner?
As to the issues that have been addressed thus far, no. Thank you.
Would the city attorney do they have any viewpoint on who should make the presentation to the board?
Obviously, that's for the commission to decide. We believe that there would be no actual conflict if Mr. Embledge gave the presentation. We do understand the sheriff's concern about perceived conflict. This was an issue that came up in Superior Court, and one way that we dealt with it, in fact, was by having the city attorney withdraw from its usual representation of this commission and the board. Normally, and this is only because of perception, not because of any actual unfairness to the parties, but normally our office would be advising and acting in many different capacities in this city procedure. We are the city's lawyers in many capacities. So we would be here on behalf of the mayor. We would normally be advising your commission, as you're familiar, in other matters. We would normally be advising the board. Those are our standard roles. And there's nothing wrong in any way with us having all of those different roles simultaneously.
Okay, well,
so
I don't want to hear about
explain, I guess, our understanding of Mr. Embledge's position in this matter. I think probably we have no official position. We think that it's permissible to have Mr. Embledge present the commission's viewpoint. My view is that the safer, more conservative route would be to have someone other than Mr. Embledge do it, but we don't believe that there is an actual conflict if he does.
Okay, thank you. Mr. Embledge.
I just want to make one clarification for the record. I was not retained by the City Attorney's Office. I have 2 retention agreements, one with the Ethics Commission, one with the Board of Supervisors. Both agreements were approved in public sessions by the respective commission and the board. Both agreements did point out that I would be advising both the commission and the board. So this is not something new. This has been out there since the very beginning, even before the beginning of these proceedings.
My concern with Mr. St. Croix doing the presentation is that he wasn't here for a lot of the hearings. He has many responsibilities, and in light of all of the resources devoted to this effort, could not attend every session. Nor do I think he's really been reviewing the transcripts. So while in most cases I think he is by far the best person to present these kinds of things to the board, I don't think this is one of those situations. I think the alternative to Mr. Embledge would be a member of the commission. I welcome the views of my other
I, for
commissioners.
one, have no objection to you being the spokesperson, even though you dissented to the result. It's laid out why you dissented, but the question that might be asked by the board, I have perfect confidence that you will make a fair presentation of what took place.
Other views of the commissioners?
Oh, I echo Commissioner Rennie's view. I think you would make a fine presentation. I think you could and have presented both sides, actually, very fairly.
We have full confidence in you, Commissioner Herr. I mean, look, you have done really a magnificent job of creating the process and running these hearings, and I don't think that any one of us really has the intimate knowledge of the page-by-page transcript of all of the questions, of all of the issues that have come up, more than you. And yes, you cast a dissenting vote. I'm not sure what the hearing will be like before the Board of Supervisors, but I don't know if I would think that those of us who can will be in attendance should there be some question. I don't have any lack of confidence in your ability. Now, you may not want to. That's a whole other issue. We haven't asked you that.
No comment. Do the parties have any objection if it were to be me?
Thank you, Commissioners, for considering the issue. I completely agree with Commissioner Hayon. I think Commissioner Herr has done a fantastic job presiding over these exceptional proceedings and would do an outstanding job before the board.
That doesn't leave you very much room to say much.
The mayor has no objection.
Okay. Okay. That I'm willing to do it. It is awkward given that I was in the dissenting view, but I'll do my best. Okay, so before we vote on the order and how it's presented, can we please take public comment on this issue?
Good afternoon, Chair Herr and Commissioners. I'm Patrick Minette-Shaw. I'm here as a private citizen today. Hearing that debate about who should make the presentation was shocking. The Ethics Commissioner has an ethical responsibility as our independent watchdog to make that presentation yourselves, not to put it off on someone else. I draw your attention to Larry Bush's CityReport.com article, that's CITI report.com. The Great Descent. Her says no. In its drive to reach the desired conclusion, the Ethics Commission's summary rewrites rather than reports, even misstating with the claim the Commission voted to find Mirkarimi guilty of misconduct on 2 of the 6 charges. That, of course, Mr. Bush wrote, is not what happened. Instead, the Commission found that all 6 charges could not be sustained as presented, dropped 4 immediately on the grounds that they were unproven, and then debated how to handle the 2 remaining charges. They did not sustain the mayor's charges. You all know that, and only one of you had the ethical wherewithal to vote no, as did Commissioner Herr. Commissioner Herr stated, if we do not find a nexus to the relationship of the duties, then we are opening this provision up to abuse and manipulation down the road in a way that we the voters, Commissioner Herr, are really not going to like. You stated, Mr. Herr, I do not think it is our job to determine what Mr. Mirkarimi's level of efficacy is going to be going forward. You implored your fellow commissioners to make a narrow and principled view of that clause that will enable those who use it going forward to apply it in a consistent way. Your report, as written, is not what you said on August 16th it would be. You have completely changed this draft summary into something you did not set out to do, but you did it anyway, much like you've done an injustice to this whole process. Thank you.
Hi, my name is Sue Grissom. If you're concerned about perceptions of impropriety, I can tell you that there is widespread perception in this town that this has been a political campaign from the beginning. Everywhere I wear this button, I get comments from private citizens saying, give Ross Mirkarimi my regards. He got a raw deal. I went to a Lower Haight Merchants Association fair on Sunday. Every merchant commented on how much they love Ross Mirkarimi and his family, from Memphis Minis all the way down to Rook Records. And every one of them say they believe he is getting a raw deal. There is a widespread perception of political impropriety in this case. I believe it should be delayed until after the election. This has been a political campaign, and there's been a lot of misconduct to go around. I believe that the domestic violence advocates themselves are engaging in illegal conduct when they come and testify here. They're a 501c3 tax-exempt organization, and to keep their tax-exempt status, they should not be advocating for or against any candidate for public office, and they've had the gall to come here and say Ross Mirkarimi should not be sheriff. That is a political campaign, and that is a political statement, and I believe is misconduct on their part. I think you should, therefore, seriously consider delaying giving your report to the Board of Supervisors until after the election. Thank you.
My name is Barbara Tangeri. I want to speak to the culture of the Latina female. There is a cultural thing here, and what you saw in the video, she was very emotional at that point. And you shouldn't take it as, well, you know, this is actual fact and blah, blah. She is Latina, and I understand because I happen to be half Latina born in Honduras, and I understand it very well. And I hope I'm not saying anything that I shouldn't say. What I have heard since day one, and I've been in the rooms, this and the other room, and had a close-up eye view and hearing to the entire proceedings, I have concluded that the charges are less than a misdemeanor. And I think that the Board of Supervisors, there are about 4 of them that are going up for re-election, and Avalos, Campos, Marr, and Chu. And without being pressured, I think that the hearing at the Board of Supervisors should be delayed until after the election. People like Malia Cohen could possibly vote in favor of, you know, Mirkarimi. But I would say, because she's not running for re-election, so I would say that try to delay it until after that. And so I want to thank you, Chair. I have admired the way you conducted the hearings. I think you've done a pretty fair job. I just would like to see a little bit more fairness on behalf of the culture of the wife. And I wish Ross Mirkarimi all the best. I hope that he gets his job back, the benefits, and his back pay, and the family coming together. I met the little boy Sunday. Beautiful. It's a beautiful family. It's not as bad as you think it is. And kind of lighten up a little bit. Let's have this go after the vote, the election. Thank you.
Hi, my name's Paula Canny. I'm not speaking as anything other than me. And I'm actually speaking to say I've realized how much time each of you has put into this and how difficult it must be. So let me talk as a little bit. So I've been a criminal defense lawyer for 32 years. That is a long time to do anything. And I was a deputy district attorney in Ventura County in this pilot project of domestic violence prosecutions, the first one in the state in 1981. I'm not for domestic violence. I'm for, even though I'm a criminal defense lawyer, I'm for love, I'm for compassion, I'm for forgiveness, I'm for the best society that we can possibly have. And so I'm saying to you, I know each of you had this hard decision to make. Some of you can't even look at me as I speak, you know, because of the situation that you've been called to do. In domestic violence cases, it's really hard to get a conviction in San Francisco County. And so the plea bargain that Ross took is the plea bargain that allows police officers to keep their jobs. It's not a crime of moral turpitude. It allows a police officer to keep their firearm. And any time a firefighter, a police officer has any sort of domestic-related charges, this is what the criminal defense lawyer tries to get as the plea bargain. And this is that standard thing. It is the plea bargain that is designed for the person to not lose their job. It is the plea bargain that is designed so that the breadwinner continues to have employment, continues to have health insurance, medical benefits for their family. It is the plea bargain that allows the criminal justice system to allow that person to be rehabilitated and to, be rehabilitated, pay their price to society and the like. And so that's what Ross did. I'm not Ross's lawyer. I was never Ross's lawyer, but he wouldn't have been convicted in a jury trial here, and instead to try and save the shame of so much of what his wife believed was a confidential video. I attribute these motives to him, and so I'm saying to you, you have a decision, we have a decision to make as a society, is that if you want to act in retribution and revenge, it's never going to be pretty and nothing's going to get better. But if you did something that allowed somebody to continue to do the good work that they do, because by all accounts, you saw it, he's worked his whole life as a matter of service to this city. And so if you believe that this act of a low-level misdemeanor warrants a person losing their job, then people are going to lose their jobs. How does that make anybody anything better? So, I know I've prattled on, and I really haven't said what I wanted to say, except that I hate that this is where it is some 10 months later. I hate it. And I feel badly for you, and I feel badly.
Ms. Canny, I think we understand your sentiment.
Okay, so here's the bottom line.
Well, you've passed your time. There will be another public comment. Perhaps you'd like to make another one at that time. Thank you. I won't comment on that either. Okay, is there a motion to approve the amended order that the commission has considered? And I think for purposes of clarity, I don't know if we have to read them all, but I think we should at least identify them all. So, Mr. Embledge, would you like to take a shot?
I'll take a shot. So I think it would be to approve the findings of fact and recommendation to the Board of Supervisors as drafted with the following changes. And as to the first, you did not specify where you wanted this, so I'm winging it. Inserting on page 6 before the paragraph beginning Commissioner Her dissented, insert a sentence that says, or a sentence and standalone paragraph that says, Commissioner Hayon supports a finding that the official misconduct in this case merits the sheriff's removal from office, period. On page 6, line 6, between the word officers at the end of a sentence and the words in addition at the beginning of the next sentence, insert two new sentences that say, in that regard, the commission did not find credible the version of the incident as described by the sheriff and Ms. Lopez at the hearing, period. Rather, the commission finds that the evidence contained in Ms. Lopez's video was more credible. Then, as to finding 7 on page 5, add a clause at the end after of his spouse that says, and the court imposed a sentence consistent with the March 12, 2012 plea agreement as reflected in paragraph 31 of the amended charges. On page 2, okay. Yes. Okay. Going backwards, I'm sorry. On page 4, line 1, add after the words except the mayor, add the words and San Diego Chief of Police William Lansdowne. And then finally, I believe, on page 2, the first sentence should be altered to read, "This matter presents for the first time..." No, this matter presents the first time that the Ethics Commission has provided a recommendation to the Board of Supervisors regarding charges of official misconduct under Charter Section 15105. That's all I've got.
One thing that we didn't include in there, and I just want to make sure that the Commission is doing this affirmatively and not by omission, we have, what's not included there is a statement adding what facts we found were not proven. While I have no particular objection to including it, I don't think it's necessary, and in my view, things that are not necessary, we're better off not including things that are not necessary. If the Commissioners feel strongly, though, I have no objection to statement of what facts we found were not proven to be included. Is there any dissenting view from that?
No, I agree.
Okay. Were there any other changes that we discussed that Mr. Emlich did not identify? Is there a motion to approve the findings of fact and recommendation of the Board of Supervisors as amended by the language? Agenda is minutes of the special meetings of April 23rd, May 29th, June 19th, June 28th, June 29th, July 18th, July 19th, and August 16th. Mr. Wagner.
Am I correct in noticing that there's no court reporter today?
Yes.
We object to the Commission having this meeting without a court reporter. There's been a court reporter at every other meeting of the Commission on this case, and I am not sure why there's not one today, but I would object to the moving forward or having the meeting at all, or the Commission taking any action today without a court reporter.
Mr. Wagner, there's no requirement that the Commission have a court reporter at any of the proceedings. This was a proceeding to ratify the decisions that were already made. Your objection is noted.
I would also note for the record that if that was going to be an objection, it should have been made before the meeting started or when the meeting started, so that the Commission, if they thought there was merit to, could have corrected it.
Thank you, Commissioner Rennie. And just to that, we were not notified that there was not going to be any court report. I just noticed in the last 10 minutes that I just assumed there would be because there's been one at every other meeting. So respectfully, that's why I raised the issue now. Thank you.
With respect to the minutes, I have some amendments. Subsequent to the April 23rd meeting, we essentially had one continuing meeting up until August 16th. So when the minutes reflect, starting on May 29th, motions that were voted on and passed, I think that's inaccurate. I think we made preliminary motions or preliminary decisions to be later ratified when the motion was made on August 16th. So I think the minutes need to reflect that in every place where we did not make an official motion but made a preliminary motion. That may have begun on June 19th. I'm not off the top of my head remembering exactly when we started the continuing motion, but if the staff could ensure that those corrections are made, I would appreciate it. Are there other changes to the minutes that were prepared for this matter? give the parties a chance to weigh in.
Peter Keith for the mayor. We had submitted some changes to the minutes directly to Ms. Zhang. They appear to have been included. We don't have any further changes.
Mr. Wagner?
No changes, thank you.
Okay. Commissioners? Public comment on this matter?
Patrick Minetshaw, I'm surprised in the minutes that you're about to adopt that you didn't note that it is customary in court orders to include motions that are sustained and motions that are denied by the court. And to that extent, I think David Wagner was absolutely correct 10 minutes ago when he recommended to you that the summary report you're giving to the Board of Supes should specifically state what you denied in finding regarding the mayor's charges. And to that extent, your previous minutes should have alerted the public that you were going to get to the point that you weren't going to include in the recommendation going to the Board of Supes what you threw out. Because most courts will tell you what they sustained and what they denied. You should have told us about that in your earlier meetings. It's the kind of unethical behavior that San Franciscans have grown accustomed to seeing from this ethical body.
Funny. 3-minute intervals. How great. I'm still Paula Canny, and now I'm not talking as me. I'm talking as Eliana's lawyer, and what she's asking me to communicate to the Board of to each of you is her dismay of the Commission's finding that her testimony was not credible. I know that you each have reasons why you're going to say that, but my client wants you to know that you're flat out wrong, and that what she said to you and what she testified to at this hearing in her heart of hearts was her truth. And that, granted, Mr. Kopp and Mr. Wagner made a strategic decision not to cross-examine Ivory Madison, and I had no control over that. But in terms of how you view her testimony here as being uncredible, she's upset, and frankly, as her attorney, I'm upset. You took a snippet of what you want to see, and I'm worried that that's what it is that rather than view something as true, the same with your dismissal of Lynette Peralta Haynes, and the way that you question Ms. Haynes. I thought she was a great witness, but again, the world is as we see it. And I see it as a place where Ross and Eliana are deserving of compassion, and I believe that the world is as you see it. It has to be that Eliana is not credible to justify your finding here, and that's disturbing to my client. In terms of the whole attorney-client privilege, I'm not Eliana's first attorney. Cheryl Wallace was. But you need to know that at the first time Cheryl Wallace had contact with the police, within really a day and a half of the video being taken from Ivory Madison, Ms. Wallace had asserted it was an attorney-client privilege document. And I know some of you were lawyers. The point is, in terms of attorney-client stuff, I have tons of people come and tell me stuff that I would never disclose to somebody. It isn't because I'm at a cocktail party, though I don't drink, or, other things where people tell me stuff. It's the belief that I tell somebody something in confidence. And if you're going to believe the video, you need to also believe that the only reason Eliana made that video was to be used in a custody dispute. not to report anything other than she was afraid that she would lose Theo. And you also have to remember at that time, she hadn't received her paperwork from ICE yet. So there were concerns. And anybody that's not an American citizen has to worry about ICE in this day and age about what's going to happen. So that's my 3 minutes.
Is there a motion to approve the minutes that we've identified?
So moved.
Is there a second?
Second?
All in favor?
Aye.
Opposed? Hearing none, the motion passes, subject to the amendments. Okay, that being the last item on the agenda, the meeting is adjourned.
Commissioner Herr, I submitted a request for the commission delaying its...
Hold on.
I submitted a request to the commission yesterday asking you to delay delivering the record to the Board of Supervisors until such time as the board may consider the case after the November 6th election due to the political pressure on each member of the board. Did you receive that, and are you going to take it aside, that question?
I have received it. I think was it sent to all the commissioners? I believe it was. My understanding is that a decision like that has been delegated to the chair. If any commissioner feels that it should be a decision rendered by the commission, then perhaps we should calendar it for another meeting. It strikes me as the sort of procedural type issue that you all have delegated to me, but if I have that incorrect, then I suggest that we calendar it for a meeting in the near future. Does any commissioner object to, does any commissioner believe that authority was not delegated to the chair to adjudicate a request such as the one provided by Mr. Kopp? Okay, Mr. Kopp, we'll decide it forthwith.
Wagoner.
Mr. Wagoner, oh, I apologize.
So I'm honored to be. One final question I have for you. There was a legal analysis of this case that was submitted, and I just want to confirm that you have received it. I can't be more specific, really, because it was submitted anonymously, though it was I found quite compelling, and I believe it was conveyed to Mr. Embledge, and just want to make sure that it's a part of the record.
Well, one thing I want to say about sort of submissions that come in, if the parties make submissions, we may consider them, we may ignore them. They will likely be part of the record in any event. When people who are not parties or witnesses to the commission submit things, it's not part of the record. We may or may not read them. We certainly have no requirement to read them. A lot of us are probably curious and do read them. Maybe we don't. But one thing that will be clear is that it won't be part of the record. I do think that things that are sent to Mr. Embledge typically get forwarded to us, if that was your question.
Thank you, Commissioner.
Anything else from the parties? From the commissioners? Okay, the meeting is adjourned.
Good job.
Thank you.